Usually, when we think about a criminal trial, there's this expectation of like mechanical precision.
Right, a clear sequence of events.
Exactly. You have an action, the evidence shows a clear line from cause to effect, and the justice system functions almost like an X-ray machine. It just, illuminates the facts so a judge can simply point to the issue and deliver a verdict.
It's a very comforting idea.
It is, because it implies that the rules of society are visible and rational and neatly categorized. But if you step into a space where criminal law collides with high-level mathematics and network theory and authoritarian information control, well, that legal X-ray machine just completely shatters.
Yeah, it really does. I mean, we're looking at a judicial landscape today that is deliberately murky.
Yeah.
The case we're analyzing pushes the boundaries of that system to an absolute extreme. It really tests the limits of what a legal framework can actually process.
And the premise of the journey we are taking you on today is, honestly, it's almost surreal. Like, what happens when a physicist uses complex mathematics to defend himself against a criminal charge, and then we ask 6 of the world's top AI models to judge the trial?
It sounds like science fiction, to be honest.
Right, but it's very real. Today's stack of sources is highly unusual. We are looking at a comparative analysis generated by 6 major large language models. So that's Grok, Gemini, ChatGPT, Copilot, DeepSeek, and Qwen.
A pretty heavy-hitting lineup.
Definitely. And these AIs analyze the official Chinese legal documents of this case. So we're talking about the indictment, the first instance judgment, and the second instance ruling.
Plus, they analyze a really unique document, a blood letter defense, written from prison by the defendant himself, a physicist named Dr. Chen Jingwan.
Yeah, a complex systems physicist writing a legal defense from a cell. But before we jump in, a quick note to you, the listener. These sources involve highly politically charged events and legal systems.
Very much so.
And as your guides, we are absolutely not taking any political sides or endorsing the viewpoints of the content. Our mission is strictly to impartially report on what these sources say and convey the ideas contained within the original material just so you can understand the core of the debate.
Exactly. We're strictly looking at the structural logic of these sources and, what happens when artificial intelligence audits a human justice system.
So we're going to explore the actual physical facts of Dr. Chen's case, his mind-bending philosophical defense, the unanimous and frankly scathing verdict of these 6 AIs, and finally, what this clash tells us about the nature of truth itself.
It's a lot to cover, but to really understand the philosophical debate here, we first need to look at the physical facts, the baseline reality of what actually happened.
Okay, let's unpack this. Let's look at the inciting incident. So Dr. Chen, who is an expert in complex systems with a PhD, was arrested in his apartment in Kunming in September 2022. And his alleged crime: it wasn't physical violence, it wasn't financial fraud. He was arrested for using a VPN to retweet content on Twitter, the platform now known as X.
And the sources detail the specific nature of that content over like a 3-year period. Dr. Chen's timeline included a lot of political satire cartoons, most notably an image of an umbrella girl.
Which is pretty widely recognized as a symbol of certain democratic movements.
Yes, exactly. He also retweeted emotional images, like candles commemorating sensitive historical events. But it wasn't just imagery. The archive included articles from dissident scholars, extensive reports from international think tanks, and even posts directly from official foreign embassy accounts.
Like the U.S. Embassy in China.
Yeah, official foreign policy statements.
Yeah.
Just a vast mix of art, opinion, and data.
And for interacting with this material, just retweeting it, the state levied the charge of picking quarrels and provoking trouble.
Which is a very specific, somewhat notorious charge.
Yeah, the sources define it as this broad cybercrime charge. Historically, it's intended for punishing the spread of fake information that causes severe public disorder. But the scale of Dr. Chen's actions totally contradicts the magnitude of that charge.
The numbers really don't line up at all.
Not even close. The legal documents reveal Dr. Chen had fewer than 100 followers, and over those 3 entire years, he made fewer than 100 total retweets. So he's being charged with inciting a massive riot, but it's the digital equivalent of whispering a hot take to a completely empty room.
That's a great way to put it. The digital equivalent of an empty room. And the legal standard for this specific cybercrime actually requires concrete proof of severe public disorder.
Right, which wasn't there.
Not at all. In Chinese judicial practice, as the sources emphasize, this severity is usually quantified by metrics. Usually you need like 500 or more retweets or 5,000 or more views. The law mandates a tangible, real-world consequence.
But there was zero evidence of any real-world disorder here. I mean, the sources mention no public panic, no protests in the street, no economic loss, no servers crash because of his retweets.
Nothing.
Mm.
Which is why, when the 6 AI models analyzed the indictment, they unanimously noted that this result requirement, the absolute necessity of proving severe public disorder, was entirely fictionalized by the prosecution.
They just made it up.
Basically. DeepSeek actually approached this exact discrepancy from a complex systems perspective, which is deeply ironic, considering that's Dr. Chen's own academic field.
Well, that's fascinating. What did DeepSeek say?
The model pointed out that a network node with under 100 followers fundamentally cannot trigger a systemic avalanche of information. It's mathematically impossible. In network theory, an account of that size generates system noise, not a cascade of public disorder. The physical riot never happened.
Okay, so since the physical x-ray showed no broken bones, no actual riot, the court had to pivot. They had to shift their entire strategy to his subjective intent.
Right, they had to prove he wanted to cause a riot.
Exactly. They had to prove Dr. Chen knowingly spread lies with the specific goal of causing chaos. And here's where it gets really interesting. How he countered this pivot is where the story elevates from just a standard legal dispute into an absolute masterclass in epistemology.
It's brilliant. He didn't just deny the intent. He used his prison defense to dismantle the court's definition of truth itself.
He deployed advanced mathematics. His prison defense relied heavily on Gödel's incompleteness theorem,
which is an incredibly unprecedented legal strategy to use mathematical logic against a state cybercrime charge.
Totally. I think the best way to visualize his defense is to look at the history of the theorem itself. So back in the early 20th century, mathematicians wanted this perfect rulebook. They wanted a closed system where every single mathematical statement could be definitively proven either true or false, strictly from within the rules of that system.
A completely airtight box of logic.
Right. But Kurt Gödel comes along in the 1930s and mathematically proves that such a system is impossible. His first incompleteness theorem states that in any consistent logical system, there will always be true statements that cannot be proven by the rules of that system. Truth and provability are not the same thing.
You can never build a box that contains the complete instructions for how to build itself.
Exactly. There will always be blind spots. And Dr. Chen took that mathematical absolute and wielded it directly against the prosecution's claim that he, quote, knowingly spread false information.
Because authoritarian censorship attempts to act as that perfect rule book, right?
Yeah.
It demands a strict binary of true or false for all human expression.
Yes. And Dr. Chen argued that because all human knowledge is essentially incomplete and fallible, he approaches all information with what he called cognitive humility.
Cognitive humility, that's a great term.
He told the judge, look, I didn't retweet these images because I inherently knew they were false, or even because I knew they were objectively true. As a scientist, he saved them as academic materials. He was treating his timeline as a repository of diverse data points for critical research.
He was basically saying that forcing an absolute true or false binary onto political opinions or satirical art or foreign policy statements, it's scientifically and philosophically impossible.
Right. I mean, an Umbrella Girl cartoon is a metaphor. It cannot be objectively false any more than, like, a poem can be empirically false.
And how did the court even respond to a mathematical proof in a criminal trial? I mean, what was their rebuttal?
This is the precise moment the legal logic completely fractured. The court basically argued that because Dr. Chen has a PhD and possesses a high level of education, he, quote, should be able to distinguish right from wrong.
Wow.
Yeah. And following that logic, they concluded he must have known the posts were fake.
Wait, really? Just because he has a PhD?
That's the argument. It effectively criminalizes his intellect. It turns a PhD into a legal liability. The court took a moral expectation that, you're highly educated, so you should know better, and just mutated it into a legal confession of criminal intent.
What's fascinating here is that all 6 AI models flagged this specific leap in logic as an illegal objective imputation.
Objective imputation. What does that mean in this context?
It's a critical concept in criminal law. It means the court used a person's external identity, his educational background, to presume their internal criminal intent. It completely bypasses the need for actual material evidence. You can't just substitute sociological assumptions for evidentiary proof.
So they took a subjective thought process and magically transformed it into an objective crime.
Exactly. And it's vital to understand the mechanism behind how a large language model actually diagnoses a legal failing like this. I mean, these models aren't humans harboring political biases. They are predictive text engines operating on vast, complex semantic maps of international law, logic, and reasoning.
They just map the logical dependencies.
Right. They look for premise A to logically lead to conclusion B. And in Dr. Chen's case, they mathematically mapped out the contradictions. They identified the exact nodes where the court's conclusions structurally skipped over the required evidentiary steps.
And what's wild is that these models are trained by competing tech giants, right? They have entirely different architectures, but they all zeroed in on the exact same structural flaws. The sources describe the result as a digital rule of law consensus.
Yeah, if you group their insights thematically, it reveals a really comprehensive, multi-layered dismantling of the state's case.
Let's break that down. Like, if we look at the epistemological danger, Gemini and DeepSeek focused heavily on the deep philosophy.
They did. They immediately recognized the philosophical threat. They pointed out how the court explicitly conflated political stance with objective fact.
Right.
They basically diagnosed the legal system with weaponizing a pocket crime, which is a vaguely defined offense designed to hold anything the state dislikes. And they used it to punish thought rather than action.
And Grok even elevated the critique to a civilizational level, right? Citing international human rights law.
Yeah, Grok framed the indictment as a direct attack on the foundations of modern legal civilization.
Then you move from the philosophy to the actual procedure. And models like ChatGPT mapped the procedural errors step by step from the indictment all the way to the appeal.
And Quinn provided a highly structured, point-by-point legal audit. It actually graded the indictment a 3.0 out of 10.
The 3.0 out of 10, that's brutal. Why so low?
Specifically because the document contained conclusions of guilt that actually predated the gathering of supporting facts.
Oh, wow. So they decided he was guilty before they even looked for evidence.
Basically, yeah. And Copilot and DeepSeek echoed that structural critique. Copilot pointed out the indictment read like a hollow template. It was as if the verdict of guilty was written first, and the narrative was haphazardly reverse-engineered to fit the desired outcome.
The procedural violations they mapped out through this analysis are just staggering. For instance, the first instance trial was held entirely in secret.
Which is a huge red flag.
Massive. According to Chinese criminal procedure law, closed trials are strictly reserved for specific circumstances, mostly cases involving state secrets, extreme personal privacy, or minors. Dr. Chen, using a VPN to retweet public embassy posts and satirical cartoons, fits literally none of those categories.
So the secrecy had absolutely no legal justification.
None. But the models uncovered an even deeper systemic failure during the appellate process.
The second instance court.
Right. The court that is supposed to review the fairness of the initial trial, they refused to even hold a hearing. They summarily dismissed his appeal with a single devastating justification. They said Dr. Chen, quote, failed to submit new evidence.
Wait, isn't that a massive violation of innocent until proven guilty? They shifted the burden of proof onto a man locked in a prison cell?
Yes. The fundamental premise of any modern legal system, the bedrock of the presumption of innocence, is that the burden of proof rests entirely on the prosecution. The state must prove guilt. But the appellate court took that massive burden and illegally dropped it squarely onto the shoulders of the defendant.
I mean, how is a physicist confined to a cell supposed to gather new digital evidence to prove his innocence?
It's impossible. And the sources highlight this as the most egregious legal error in the entire timeline. It sealed a fundamentally flawed judgment without the court ever having to review the actual facts of the appeal.
The AI models unanimously recognize this, not just as a procedural mistake, but as a complete abandonment of the appellate court's core judicial duty. The system just functioned on autopilot, stamping guilty as the paperwork moved down a bureaucratic conveyor belt.
So what does this all mean? You really have to ask yourself why the mechanics of the specific case matter to you on a broader scale. We have a physicist with a tiny digital footprint, a brilliant mathematical defense based on the limits of human knowledge, and an unprecedented AI audit that proves the legal mechanics were totally broken.
Right. Why should we care?
But the underlying architecture of this case represents a much larger global blueprint for information control.
If we connect this to the bigger picture, this case serves as a terrifying blueprint for how modern information is controlled. The sources explicitly define this phenomenon as textual inquisition 2.0, or in Chinese, Wenziu 2.0.
Textual inquisition, that has a lot of historical weight to it.
It really does. To give that some historical context, during imperial times, specifically the Qing dynasty, a scholar could be imprisoned or even executed simply because an imperial censor interpreted a poem or an essay as subtly mocking the emperor.
Wow.
Yeah. Textual Inquisition 2.0 updates that terrifying concept for the digital age. It replaces the imperial censor with algorithmic surveillance, VPN tracking, and vaguely defined cybercrime laws that basically criminalize digital footprints.
And the analysis points out this approach directly violates the Chinese constitution's own legal protections. Article 35 guarantees freedom of speech, and Article 47 protects the freedom of scientific research.
It's not just a breach of abstract international norms. The system is fracturing its own foundational code. It's violating its own constitution just to secure a conviction against a node with under 100 followers.
Which brings us to the ultimate collision at the heart of this deep dive. We are looking at a fundamental clash between two entirely incompatible ways of processing reality.
A clash of rationalities.
Exactly. On one side, you have the open epistemology of science, championed by Dr. Chen's defense. In this framework, knowledge is rigorously debated. It is understood to be inherently fallible. Multiple diverse perspectives are considered absolutely necessary for a healthy system.
And doubt is recognized as the primary tool for discovery.
That is the essence of the cognitive humility he was talking about. It's the acceptance that the rule book is naturally incomplete, and that truth requires continuous skeptical investigation.
On the other side, though, you have a closed authoritarian system that demands an absolute monopoly on truth. It simply cannot tolerate ambiguity or metaphor or systemic noise. And the reason this dynamic is so critical for you to understand is that it highlights the profound danger of any system that attempts to criminalize doubt.
Whether that's a government structure or a massive technology platform, or even a rigid corporate policy, mandating a single, unchallengeable version of reality is dangerous.
Very. The moment a system declares it holds the absolute truth, it has to treat any question, any piece of satire, any divergent data point as a direct threat to its existence. Disagreement is no longer categorized as a difference of opinion. It gets reclassified as the malicious spread of falsehood.
And that is the exact sleight of hand the court used against Dr. Chen. They took an Umbrella Girl cartoon and a dissenting academic opinion, labeled them objective facts, and then punished the man for getting those facts wrong.
As we step back from the granular details of Dr. Chen's imprisonment and this whole AI analysis of his trial, there's a profound, almost poetic irony hovering over this entire narrative.
Oh, absolutely.
Think about what these 6 AI models fundamentally are. They are entities constructed entirely out of rigid code. They operate on binary ones and zeros. They are the ultimate, literal expression of mathematical absolutes.
Right. They are literally machines.
Yet these rigid synthetic machines were able to unanimously recognize, understand, and vigorously defend the nuance, the uncertainty, and the cognitive humility of the human mind.
The machines recognize the vital gray areas that the humans in the room absolutely refuse to see.
Exactly. The human judges the individuals who are theoretically supposed to exercise empathy, who are tasked with understanding the complexities of human intent and the subtleties of art. They behaved exactly like unthinking, rigid machines.
Just blindly following a script.
Yes, they blindly processed a bureaucratic algorithm to achieve a predetermined result, ignoring logic, evidence, and mathematical reality along the way. So you have to ask yourself, what does it say about the future of justice if our machines are better at understanding human intellectual freedom than our human institutions are?
That is a chilling thought. Our legal X-ray machine isn't just misdiagnosing the crime, it's misdiagnosing the very nature of what it means to think. Thank you for joining us on this deep dive into the collision of mathematics, law, and artificial intelligence. Keep questioning the absolute truths presented to you, keep seeking out the blind spots in the systems around you, and above all, embrace your own cognitive humility.